Welcome to navigating Kaiser Permanente's arbitration process. My name is Ramey Diamrian, Chair of the BHBA Barristers Section. I am delighted to introduce our speaker today, the Honorable Mark Pierce. Judge Pierce is a mediator and arbitrator with signature resolution, where he brings a refined approach to conflict resolution grounded in civility, fairness, and deep listening. Judge Pierce began his legal career in 1975, inspired by a lifelong interest in history, political science, and a family culture of service. After completing mediation training at Harvard in 1994, he focused on resolving disputes across a broad range of areas, including business, employment, medical malpractice, and personal injury. In 2005, he was appointed to the Santa Clara County Superior Court by Governor Arnold Schwarzenegger, where he served for 15 years. Throughout his career, he remained active in his community and professional organizations, building a reputation defined by empathy, patience, and an unwavering dedication to justice. And now, let's get started with the program.
Thank you. I'm happy to be able to present this program today to give you some additional information that you may not be aware of with regard to the Kaiser Permanente arbitration process. In California, it's a unique situation where Kaiser members are required to participate in an arbitration program if they have a claim against Kaiser. This has been a long-standing program with Kaiser, going back many years, and it's a program that is somewhat unique in the medical field, and is one that is very distinctive in the way that it is set up. There are over 9 million members of Kaiser in the state of California. And when I speak of Kaiser, I'm really referring to Kaiser Hospitals, and as a separate organization, the Permanente Medical Group, which is theoretically the physicians that are employed by Kaiser. And when I refer to Kaiser today, I'll be referring to both Kaiser as the hospital and as the Permanente Medical Group. As I said, the Kaiser program is unique in that when a person becomes a member of Kaiser, they sign an agreement that states that basically any claims against Kaiser must be arbitrated. And as a result of that, if one is attempting to make a claim against Kaiser, it will be required to be in arbitration. The rules are such that the courts have uniformly enforced this arbitration agreement, and it is a requirement then of any Kaiser case that it go to arbitration. The program itself can be, that is, the arbitration process can be started in several different ways. Sometimes people will attempt to file a civil lawsuit, for example, in Superior Court against Kaiser. Kaiser routinely will file a motion to compel arbitration, and the courts have routinely enforced the arbitration agreement. Now, there is one exception, and that exception is under the EFAA, which is the end of forced arbitration for sexual assaults. It's a recent law that was passed in 2022. And what it is basically, it states basically that a victim of sexual assault or battery cannot be mandated to participate in an arbitration process. This is a unique situation for Kaiser in that it is perhaps the only exception that there is to the arbitration process. What it does is it creates an interesting situation from a legal standpoint in that you potentially can have a claim that a person is making for sexual battery, for example, against a Kaiser employee, and Kaiser itself. And what can happen is that you can have a separate a civil action for the sexual assault, and a separate arbitration proceeding for the claim itself against Kaiser. And this presents some interesting legal questions as to the potential for having different results if you have two separate cases going on involving the same situation, the same issues. In any event, I haven't actually seen that occur yet, but it certainly is a potential and one that has to be dealt with. Now, there are obviously the medical malpractice cases against Kaiser are the most common claims that are made. But one needs to be aware of the fact that any claim against Kaiser, except as I just talked about with the sexual assault, needs to go through the arbitration process. And what that means is that a slip and fall in the parking lot when you're going into for treatment, something of that nature, that is a claim that you are required to arbitrate through the Kaiser arbitration process. So it's not just med mal cases. It is all cases against Kaiser. The rules for Kaiser arbitrations have changed over the years. Initially, for those who have some history, if you will, with regard to Kaiser, will realize that as much as 30 years ago, the Kaiser process was such that if you had a claim against Kaiser, you would file the claim, and then you would choose your own arbitrator, and Kaiser would choose their own arbitrator, and the two arbitrators would then choose a neutral third arbitrator. And this was the process for many years. Unfortunately, as one could imagine, it wasn't a very efficient or very good process. And you could imagine, and I had this actually happen way back when, many years ago, that you choose, a competent attorney, for example, if you're the defense attorney, to be your arbitrator. And similarly, the plaintiff's attorney chooses a good, competent attorney familiar with malpractice cases. And then, of course, they choose the third arbitrator. Now, one can only imagine what it was like way back when you were trying to schedule something with these arbitrators, because they're uniformly busy. They're not full-time arbitrators. They were generally attorneys practicing law with busy practices. And so they would have to make time for these arbitrations. Now, they were paid by the party that requested them, but still, the fact of the matter is that it was extremely difficult to get something scheduled. For example, to schedule an arbitration, you had to schedule it with the attorneys obviously representing the parties, but also the three arbitrators. And it was very time consuming, very difficult, and led to many delays and so on in the process that were really unacceptable. As they say, the old adage that justice delayed is justice denied was really that sort of an issue. So as a result, there was a case that was then went through the courts and became law that I refer to as the Ngala case. And in that case, the court considered the Kaiser arbitration process and found that there were unnecessary and needless delays, that the program was not correctly supervised. There were no independent parties that were running the program. And as a result of it, it just wasn't a good program. And the court ruled that Kaiser effectively had to change it and do something different. As a result of that, and I gave you the citation, I think, on Ngala, it's really the fact that it was done and as it was completed is the important part of it. It really has been, over the years, made to be unnecessary because of the new rules that Kaiser had established. And I'm also looking here to see, I see that there may be, and I will also encourage you to ask questions during this program if you have something that comes up that you want me to respond to. Okay, I see there's a question of a case, Chloe Brockman. I'll have to answer that later. In any event, the as a result of Ngala, and basically the Office of the Independent Administrator was established by Kaiser. And this is a very crucial and important organization that was set up to deal with Kaiser cases. Actually, the Office of the Independent Administrator is employed paid for by Kaiser, but they're not an employee of Kaiser. They're a separate organization in Los Angeles. They are they actually are attorneys that are simply responsible for maintaining and organizing the arbitration process. As I said, the office was established after Ngala, and it set forth a lot of very comprehensive rules. It set forth requirements for the maintaining new panel of arbitrators and so on. And it was very critical and very crucial at the time. And you'll find information about that at their website, which is oia/kaiserarb.com. It's a very comprehensive website, includes lots of important information about, dealing with Kaiser cases, choosing arbitrators, and all of the rules that go along with that. So the Office of the Independent Administrator, as I said, is responsible for literally everything involved in Kaiser arbitrations. They have, as I said, a network of rules, regulations, and so on to make the process effective. And they do a very good job, in my opinion, in doing so. They encourage rapid resolution of cases and claims, and it's helpful, I think, in trying to give everyone their rights under the law and still maintain effective legal processing. Okay, there's a question here that I have with regard to is jurisdiction lost to hear a motion for reconsideration once a neutral arbitrator makes his ruling. We'll get to that later, but the bottom line is, yes, you can't, there is no authority for reconsideration of an arbitrator's ruling unless, of course, there's some sort of issue. So the Office of the Independent Administrator is designated to handle all claims in California, both Northern California and Southern California. They operate out of Los Angeles, but they are effectively, operating throughout the state. They have set forth extensive rules for the Kaiser arbitrations as far as how to start an arbitration and so on, and requirements for the choosing arbitrators. The initial thing that's, of course, is important in a Kaiser type arbitration is how do you initiate the claim? As I said, if you try to file a lawsuit in civil court, the Kaiser attorneys will move to compel you into arbitration. You can The other way, of course, the most simple and the straightforward way of starting a Kaiser arbitration is by simply filing a claim against Kaiser, and you can do that with the office of the independent administrator. There is a filing fee of $150. That filing fee can be waived under certain circumstances for indigent type situations. But basically, that fee is required, and that is the thing that starts the process. Now, there's no formal claim form that you must use in order to initiate an arbitration. Actually, the OIA does have a claim form that you may use to initiate an arbitration, but it's not mandatory. The fee is mandatory, but not the form. Once the form or once the claim is filed, then that starts the whole process. Now, I think that it's important in filing the claim that the party spell out what the nature of the general claim is. In other words, so that Kaiser has a little bit of an idea what's going on, because I found in handling a number of arbitrations that initially Kaiser has no idea what the claim is about. They don't know anything, and just because a claim was filed, it doesn't always spell out what the nature of it is. And in this situation, it is helpful and important that the claim be spelled out. Once the claim is actually initiated, the process then begins of choosing an arbitrator. Now, there are several different ways in which you can choose an arbitrator. And first of all, you can stipulate to an arbitrator. Sometimes you can even stipulate to an arbitrator who is not on the Kaiser panel. That's pretty rare, I think, because the advantage of the Kaiser panel is that the people are experienced in medical malpractice cases and are aware of the various issues in med mal cases and are much better prepared to handle that. Now, another way that you can choose an arbitrator is by going to the OIA website, and they have a list and photos and so on of all of the arbitrators that are qualified through OIA. And they've all been vetted for their experience and their knowledge of medical malpractice cases. And the important thing with regard to choosing an arbitrator is that you are cautious and careful about that. And if you can stipulate between both sides to a person, I think that you're much better off, and it is very helpful. However, as often is the case, parties are unable to agree as to who the arbitrator should be, and as a result, they will request that OIA appoint an arbitrator. Now, the panel of arbitrators, as I indicated on the OIA website, consists of about 50% retired judges and 50% non-judges, if you will. And there's no requirement that you choose a retired judge or not. The other thing is that one needs to, be aware of who the arbitrator is, because as I've indicated previously, it's the arbitrator's award is going to be final, and you are going to be stuck without any basis for appeal of an arbitrator's award. So being cautious and careful in choosing an arbitrator is a really good idea. What happens when you're not able to agree on a particular arbitrator is that you submit you advise the OIA that you want a list, if you will, And basically, that is a situation where you have a rank, you will get a list of arbitrators, about 10 or 12 or so, out of which you are able to strike a certain number of them, and then you rank the remaining arbitrators on the list that you get. And each side does that. And then it's submitted back to the OIA. And then as a result of the ranking system, the arbitrator initially will be appointed. The arbitrator then is appointed and is advised of his or her appointment, and she has an opportunity to accept the appointment or not. Generally speaking, the appointments are accepted, and this process, hopefully only takes 30 to 45 days. Again, the idea with the arbitration program with Kaiser is to get the remedy and the resolution of the cases moving along without unnecessary delays. Now, with regard to filing the claim, it's interesting. You will find that there are statistics on the website that can be helpful, but you will find on the website that the number of claims against Kaiser has gone down substantially over the past 20 years. Don't know exactly why that case is, but I do know that it is important that the claims are handled judiciously and effectively, and I think that the new system, the OIA system, is doing a very good job doing that. Now, the interesting thing about, as applies in a lot of our arbitrations that are compelled, is that in a typical arbitration, Kaiser will be responsible for paying all of the expenses of the arbitrator and any other expenses in the arbitration, such as a court reporter, that sort of thing. Now, there are different situations that arise. For example, if the claim is less than $200,000, the situation is that one arbitrator is to be selected and chosen to be the arbitrator for the case. In a case that has a value, and it needs to be stated in your claim, if the claim is more than $200,000, you're required to waive the right to have more than one arbitrator. And in the case of the Kaiser situation, if you have a case that's valued where the claim is more than $200,000, and you want to have one arbitrator, again, paid for by Kaiser, the expenses all paid, both parties need to waive their right to have multiple arbitrators. You are allowed in like the old system is to choose your own arbitrator. Each side can choose their own arbitrator, and then that arbitrator chooses the neutral arbitrator. So you would have a 3 arbitration panel. This is like the old system, and it has some significant, in my opinion, disadvantages. For example, each party is required to pay their own arbitrator and half the expenses of the neutral arbitrator. So it can be a very costly situation. And it's fairly unusual to have that situation arise, although I have heard it does occur where the parties are insisting upon the 3 arbitrator panel. So if you want that, it's available, it's costly, and it's something that one should think very seriously about. Now, there are other things that you need to consider when scheduling or choosing an arbitration through Kaiser, and that is that you can designate the case as a complex case. That and that's just a request through the OIA to designate it as complex. And the reason that you might do that is that would give you more time to resolve the discovery issues or to handle the issues that may come up in the case, such as um, uh, discovery issues and that sort of thing. Um, I see that I have some more questions here. See if there's some of them that I can answer. Okay, there's a question here about the question of a civil rights or anti-discrimination claim. Um, how do you handle that? Well, that again is one that can and should be handled through the arbitration process. Again, unless there's an exception, such as the sexual assault issue, I think that it has to go through the Kaiser process. Okay, I have another question with regard to a wrongful death claim in an arbitration. Um, the question is, with regard to an arbitration of a wrongful death claim, um, the negligence claim, it has to be handled separately. And I think that um, it would be unusual for them not to do so. Okay, I have another question here with regard to discovery tools such as depositions, interrogatories. Are they available in arbitration? I'm going to be getting to that. So hang on. All right. As I said, the arbitration expenses are an expense that is typically paid for by Kaiser. And those include, the cost of the arbitrator, which can be, fairly expensive. The arbitrators are, as I said, private attorneys and retired judges, and their fees are significant, and one has to be aware of that. Now, when the Kaiser process was set up, I mean, it was intended that I think initially that, of course, they would be in person. But times have changed, and the process for handling arbitrations has changed greatly. You find now that the arbitration process can be done entirely by a Zoom type proceeding. In other words, I'm aware that there was a birth injury case, a 3-week birth injury case that was heard during the issue when COVID was an issue, and that case was handled entirely by Zoom, which is shocking to me and amazing to me because, of course, it's a very serious case, and the idea that there would be no live bodies present is pretty shocking to me. But I'm an old coot. I do believe that the new system that is evolving is very good, and it's good for a number of reasons. Basically, what I see evolving now for purposes of the arbitration process itself is that the arbitrations are becoming what I would call hybrid, meaning that the parties will oftentimes the parties themselves will appear personally before the arbitrator in the arbitrator's usually the arbitrator's office, but some of the witnesses will appear by Zoom or other video type conferencing. I think that this is a pretty good process. Because over the years, if one who has handled med mal cases knows how difficult it is to arrange for physicians to testify. They have busy practices, and they have lots of things going on. And the idea that some of the physician witnesses in particular can testify, and other expert witnesses as far as that goes, can testify by Zoom makes things very efficient and very good, I think. I still prefer to see a live body in an arbitration proceeding, but that's not to say that they don't get that someone who is appearing by Zoom doesn't get full faith and credit for everything that they say, and just as much as just believable as anybody else. However, the process is evolving, and I'm finding that it's different at different times of the year and different parties. Some people, I find some attorneys now are not even operating in state. They're living out of state. They can handle the arbitration proceeding totally by Zoom while living in another state. That's pretty incredible for me, as an old PI lawyer way back when, to think that everything would be done by Zoom. Um, that's perhaps an exception, and perhaps for a smaller case, but in any event, that is the way that these cases are being handled, and they are being done both in person, totally by Zoom, and a hybrid, which I think is the most common way that things are going right now. Now, one of the questions that was raised here was what are the discovery processes and what rights does people have for discovery and that sort of thing. Well, the discovery and the civil procedure aspects of an arbitration are virtually identical to that of the civil process in the courts. And that's what I have found it works best. And so, for example, the arbitrator has the right to subpoena records, to issue subpoenas. The arbitrator also has the right to issue subpoenas for witnesses, and to compel records to be produced by outside sources. Now, when it comes to parties, I think that most arbitrators follow the rules of discovery that are set forth under the Code of Civil Procedure, and the time frame that is set forth for that type of discovery. I find that, for example, that Kaiser is very cooperative in providing medical records and that sort of thing, and I think that they the process of obtaining records is generally pretty smooth and pretty good. Also, with regard to taking expert witnesses and percipient witnesses' depositions, that process seems to work pretty well too. I do have in my practice, as an arbitrator, I do have issues that will occasionally come up, and what I tell the parties is that if they have any disputes about discovery, don't file a long motion. Don't file, lots of things until we talk about it first. I find that so many issues in these types of cases can be resolved by simply talking about it and ironing out issues that may be someone may be confused about their rights and their requirements that they have to do. So you can expect that in arbitration that discovery is going to be similar, although somewhat more informal than you would see it in a civil court. I find that attorneys seem to work well for the most part in arbitrations. I think that there's not a courtroom or a courthouse that's sort of in between them and whatever is happening with the case, and that people seem to work better and more smoothly and efficiently in the arbitration proceedings. Occasionally, there will be specific issues about compelling an answer to a specific interrogatory or something of that nature. And I find that by talking about it and working through it, most often it's able to be resolved. And rarely does there have to be an order about something like that. It just is a much smoother, easier going process than you might find in a regular court. I'm looking to see if I have any other questions. Now, we talked a little bit about the actual hearing process um, as to where we would have that type of a hearing, and basically, again, it's much more efficient, frankly, than in a courthouse because we're able to schedule things more much more easily, and we're able to be more flexible in scheduling witnesses and that sort of thing. Um, Now, the typical arbitration process is that it's, as I said, is it's usually held um, in the arbitrator's office, whether it's by Zoom, even by Zoom, or by in person or hybrid. Um, in an arbitration, uh, med mal arbitration, such as the Kaiser process, the rules of evidence apply, and I follow all the rules of California evidence. Perhaps a little bit um, more simplified as far as some of the rules of objections with regard to um, foundation and things of that nature. It depends on the arbitrator as to how strictly they want to follow the rules of evidence. But of course, the basic rules of evidence have to be followed at all time with regard to hearsay and things of that nature. But basically, the process itself is fairly straightforward with regard to um, the testimony of witnesses. With regard to admitting records, medical records, whether they're Kaiser records or other employment records, for example, usually we are able to not have to have custodian records appear, that sort of thing. Excuse me, it makes it a more simple process to get things done and move along more quickly. So I think that you can find that an average med mal arbitration might take 4 or 5 days, whereas a case like that could take several weeks in a civil trial setting. Um, Generally speaking, the witnesses can be uh, arranged for in advance, and sometimes nowadays we're using the videotape depositions. They can be played when there's um, a lull in the evidence, if you will. And so it works fairly well that we were able to um, make the process uh, work fairly smoothly. Uh, One of the issues that has come up in some of my uh, arbitrations is whether or not one wants to have a court reporter present, um, because these days it's tough to find good court reporters that are able to appear. And one of the problems is that the attorneys oftentimes want daily transcripts if they have a court reporter. And of course, that puts additional pressure on the court reporter. Sometimes you have to have two court reporters. And so I'm lukewarm as to whether or not one needs a court reporter for these med mal hearings or not. Um, I think it's again up to the parties, and it may be up to the decision of the attorneys as to whether or not it's really necessary or not. It's definitely an additional expense, and it's additionally difficult, like I said, to get a court reporter who's going to be able to do that and do the dailies also. So I think that one would have to consider the the importance of having a court reporter or not. Now, the hearing usually, as I said, is done in the arbitrator's office, and usually the facilities there are really good for Zoom and that sort of thing, so that everything usually goes pretty smoothly. The award then, once the hearing is concluded, is required to be done in 30 days, or if it's a complex case, it can be a little bit longer. But the idea again is to move these things along, we're able to get the decision done as soon as possible. Okay, I have a question. I think that the rules, there's a question as to whether or not CCP 425.13 with regard to punitive damages, whether that applies or not. Again, I treat that exactly as it would in a civil court. And so, the requirements for proving punitive damages would be the same. Then I have another question here asking whether or not the arbitration award is appealable. And as I indicated earlier, it is not appealable. That is a final decision. The only grounds for appeal would be not on the merits of the case, but on the issue of was there a mistake by the arbitrator in the process, or was there a mistake or fraud by the arbitrator, something of that nature. But it's really not appealable on its merits per se. Okay. I have another question here. Who pays for the court reporter? Well, my belief is that because Kaiser is responsible for the expenses of the arbitration, they would be responsible for the court reporter. Let's see. I'm reading these questions. Suppose a wrongful death claim in arbitration. I think I already answered that question. Okay. I think that the any wrongful death case, it's treated as the same as it would be in a civil court. Okay. One thing that I think we should discuss a little bit is, and it doesn't necessarily apply to the attorney so much, but you should be aware perhaps for your own clients if they have a claim that they want to pursue that you don't want to pursue. That happens sometimes, and maybe even a smaller claim. But the issue of self-represented litigants is an issue for Kaiser and for the arbitrators who have to deal with that situation. The process through OIA is set up to allow people to represent themselves. And in fact, as many as 20 or 25% of the cases are people who have filed claims on their own behalf and are attempting to represent themselves. The problem, of course, here is that in a med-mal case, the proof required is going to be such that most likely the self-represented litigant is going to have expert medical testimony to testify as to the standard of care that's required in that particular case, and if there was a violation of that standard of care, what that violation was. Now that, of course, anyone who's ever handled medical malpractice cases knows that obtaining medical testimony is a difficult challenge. It's not easy to do, and particularly for someone who is representing themselves, it's very challenging for them to try to represent themselves and have medical testimony. What Kaiser generally does in these situations is they will file a motion for summary judgment or summary adjudication, if you will, and present evidence that there was no violation of the standard of care. And generally speaking, self-represented litigants are going to be out of luck because they're just not going to be able to present medical evidence. Now, as soon as I said that, I had a case recently where the Kaiser attorneys submitted a motion for summary adjudication, and the self-represented litigant, and of course they thought there would be uh, no opposition. The self-represented litigant did find a physician to testify and submitted a declaration that there was a breach of the standard of care. That's pretty unusual, but it does happen, and it can happen, and it's necessary to be aware that's a problem. But self-represented litigants, their cases generally go away because it's so difficult for them to pursue that case. But it is something that is encouraged by OIA to let people at least potentially have the opportunity to have their claim be heard. Now, before we wrap up, I did want to talk a little bit about the resolution of these cases, out of arbitration. As I said, there are, there's over 500, 600 claims filed each year. Many of them are dropped. A few of them go to actually go to hearing, but many of them are resolved out of the arbitration process. And I think that attorneys who want to participate in the Kaiser process should be aware that number one, it's going to be very expensive for them. Any attorney who is handling a med mal case or who has ever handled a med mal case knows that physicians are extremely expensive, whether they're testifying as an expert or even as a recipient witness. Sometimes you have to pay them too. And so the cost of these cases is extremely high. My experience is that, and of course, it's expensive for Kaiser too. And my experience has been that Kaiser, when there is a case where they have some exposure, they're not a hard liner per se. They will resolve a case where they have some exposure. On the other hand, if they don't feel they have any exposure, they're not inclined to offer nominal or cost of defense settlement offers. I mean, they will pursue a case to judgment if they feel that there is no liability, and they will not offer a nuisance settlement, in my experience. I think that that an early discussion between the attorneys about the case is really helpful. In other words, if you have a medical negligence case, and number one, as a plaintiff's lawyer, you should have gotten an expert witness ahead of time who's going to say that there was something that was done wrong, and who is competent and capable of testifying, and who's willing to testify for you. Having that information, I think, and this is not always agreed to by everybody, but my feeling is that an early discussion between the attorneys, where the plaintiff attorney feels that they have a valid claim, and they have evidence to support that claim, I think an early discussion in the form of like a mediation of some sort is very helpful. And I think that there are several ways that you could go about that. One would be simply just a typical mediation where the parties sort of lay out their cards early on, before for example, the attorneys, and of course, everyone has to spend money on experts, and so Kaiser spends money too. So I think it's to their advantage early on to have a discussion about, if there's a legitimate claim, to talk about what resolution might be hammered out. So that's more the standard or traditional mediation. But again, it would be, I advocate doing it early. Now, one of the things that people will claim is that they don't have the medical records to review, and yada, 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 that sort of thing. But I think that you can find that in most cases, the parties can get enough together to have a pretty good idea of where they stand and what they could do. Now, In a catastrophic case, no, this is probably not going to work. But I'm talking about the more, average case where there's been a mistake, perhaps an oversight, that something might be worked out early on. Now, another thing that takes it even a step further is by using a mediator as a sort of a, if you want to call it a referee, okay? And that meaning that, and this is kind of my own thoughts on this issue, which I think is potentially something that should be worked on, is that you can hire your mediator slash referee to sort of set some groundwork for perhaps an early resolution of the case or early discovery in the case to indicate the strength or weaknesses of the case. And in my own personal experience, I had a case many years ago where the defense attorney who I knew, and I was representing the plaintiff, the defense attorney whom I knew and respected said, tell me what you got. Well, a lot of people are really hesitant to do that because they're afraid that they're just going to be turned around on them. But in this particular case, I felt like the I could trust this attorney to give me a straight shot. And in fact, what I did is I actually presented my expert witness for a conversation with this defense attorney as to what the grounds were, why he felt that it was medical negligence and so on. Interesting, different approach to handling that kind of a case, but you know what? It worked. And in that case, my client was very challenging. He had mental health issues and so on, and we were able to resolve that case early on because I had my expert lined up, and he was going to be, a pretty effective, strong witness. So try to think of alternatives to trying to get cases resolved early. As I said, assuming that you and a person representing someone in a med mal case has medical expert testimony and is prepared to go forward, I think that they should consider ways of giving the defense attorneys an opportunity to know that the exposure that they have in the case. Of course, there's always a question, well, if you tell them what you got, then they go out and try to find somebody who's going to rebut that. Yes, that's an issue, and that always will be an issue, and that's a risk that you take. And so I throw that out as only a possibility, as a potential that somebody might want to try in order to resolve what can be a very expensive proposition, and that is, taking on these medical fees and the expert witnesses and so on. I think I have another question here. There's a question. It says, what is the process to have Kaiser pay the full fees for the arbitration? That if if there's one arbitrator, the Kaiser pays the fees for cases less than $200,000, and if you stipulate for a claim more than $200,000, they pay all of the fees. Another question is, what if the arbitration hearing is held beyond 24 months? Depending upon, you're going to have to get permission from the OIA to do that. But if you get permission to do that, it can go longer, again, if it's designated as a complex case. Okay, so if Kaiser erroneously cancels my policy while I am pursuing my claim and waives my right to go to arbitration, do I have a viable claim in civil court? No, I don't think so. I don't think you do. I think you have to pursue the claim in arbitration, whether or not you are continue to be a Kaiser member or not. Okay. I think that I have answered all of the questions that were poised, and I have basically covered all the issues that were put before me today. The Kaiser arbitration program is one that is unique. It's different in the legal, our California legal system. But I do think it's a valid and good process, and that through the OIA that the all parties are able to get a good resolution, including the ultimate, end result of the case. So that being said, I'm going to go ahead and conclude the program today, and I thank you all for being present.
This concludes today's presentation. Thank you so much, Judge Pierce, for sharing your knowledge and for giving your time to our members today. And thank you so much to our audience. Have a great afternoon, everybody.